Hello guys, welcome back to our video update. It's Sade. Today's video is going to discuss trusts, or what some people call land trusts. The reason I'm covering this today is because we're getting questions about when trusts are useful, what they're useful for, and how to create one. So this is for educational purposes. As always, I'm covering this from the perspective of the state of Texas because that's where I practice, and I'll just give you a general overview, and then you decide whether this is something that will be useful for you. I think it's useful for everyone, whether you're an investor or just an individual that would like to protect your assets. And of course, if you're in other states, make sure to consult with an attorney in your state, and you also would need to consult with a CPA for the tax ramifications and the tax implications that we need to think about before we put the trust agreement together. A trust, as it sounds, is essentially a sort of agreement that implies that one party is putting their trust in another party for purposes of managing and holding something of value, like an asset or a piece of property. So the trust agreements can be verbal, but of course it's easier to enforce something that's in writing. So you do want to have it in writing, and you want it to be fully executed by all the parties. And the parties that are involved with a trust agreement would be three main parties or groups of people. So if you think about it in the form of a triangle, you have a grantor, who is the party that's coming up with the property that the person is going to entrust with another party, called the trustee. So the grantor is also sometimes called the trustor or the settlor. They would pick a trustee that would help them manage and hold the property for the benefit of the beneficiaries. So you have the grantor, the trustee, and the beneficiary as the three parts of that triangle. The part where it gets confusing is that a lot of the times the grantor is also a beneficiary of the trust, and the grantor can also be the trustee of that trust. So each party can play several roles in that sense. So it's not a true triangle all the time, but the legal relationships are in the form of a triangle. In the case where you have a grantor that's a parent, for instance, that parent might want to hold real estate in trust for a trustee to look after the real estate and manage the transactions that are needed until that grantor passes away. So that grantor would pick maybe a cousin that they trust, and sometimes they'll pick their own child that they trust, somebody with financial integrity, with some savviness, somebody that's a little bit diligent, or a lot diligent actually, and maybe well-versed in real estate matters, or just generally somebody sharp, right? Sharp and trustworthy. So that's who they typically would pick, unless they pick themselves as the trustees. And then the parent will then say that they also want to be the beneficiary of that trust while they're alive. And a lot of the times they can have a contingent beneficiary. So the grantor would in that case be the beneficiary, and when the grantor passes away, the contingent beneficiaries would be the ones who inherit the properties that are held in trust. So those contingent beneficiaries are typically the children or the grandchildren. So that is the general structure of a trust agreement. The trust agreement, like I said, is usually in writing, so you can put different terms in there, and no two trust agreements are alike, in my opinion, because it really depends on the circumstances of the parties involved. It depends on the purpose, the main driving purpose behind creating the trust agreement, and the types of benefits and advantages that the grantor is looking to get out of that land trust agreement. So I'll go in a little bit into those, but first let me go over the terminology that you'd hear out there in public. The main terminology that I've seen is that people talk about a living trust and a testamentary trust, and they also talk about a revocable trust or irrevocable trust. And I'll go over the differences really quickly. The living trust is exactly as it sounds. It's a trust that I've created that's effective while I'm alive, right? I created it while I was alive. I funded the trust while I was alive, because funding the trust is what makes it effective. If I create a living trust and I did not actually transfer any real estate into that trust and then I pass away, it was never really a living trust. The living trust is created while I'm alive and it's funded while I'm alive. The testamentary trust, on the other hand, it is created by my will once I've passed away. So those are the main differences. And then when it comes to revocable and irrevocable trusts, the main thing to keep in mind is that the revocable trust can be revoked, just as it sounds. It can be canceled, it can be changed. The terms can all be changed by the grantor that created it, okay? So that's what makes it revocable. If the grantor is not a beneficiary of the trust, typically that means it's irrevocable, because the beneficiaries are the ones that control the actions of the trustee in terms of title to property held by the trust, as well as the disposition of the property held by the trust. So the beneficiaries control the trust. So if the grantor is not a beneficiary, it's probably an irrevocable trust. So what makes sense for each situation is different. I would say that if you wanted the probate avoidance as an advantage of creating that land trust, then you wanted to create the living trust. You want the trust to be funded while you're alive, and then you don't have to worry about it being created after you're dead, right? So the properties are all passing while you're alive, and the trustee can then just go ahead and dissolve the trust once you pass away, and they don't have to worry about probate. The revocable one is okay as long as you think you want to change things in the future and whatnot. It's also okay that you're a beneficiary if you would like some control while you're alive. However, when you're trying to avoid most of the federal tax consequences, it's easier when you have it set up as an irrevocable trust, because the corpus, which is the main part of the trust, the things held in trust, the value of that is not counted against your estate if you're not in control of the trust. Let's say it's irrevocable. So if you're not a beneficiary of that trust, for instance, it will not be counted against your estate when it comes to federal taxes. So those are the things to think about. Talk to your CPA about all those different things and see what works best in your situation. So I've already started talking a little bit about the benefits of having a trust, right? So one benefit is to avoid probate, because probating a will can be very costly and very lengthy and very, very cumbersome, especially if family members disagree and people fighting, you know, and contesting the will and things like that. So sometimes you can avoid probate altogether by putting all the assets basically into the trust and then mentioning in your will that any remainder of your estate would pour over into that trust. That means that the trustee now has 100% control of your whole estate. So there's really nothing left to probate in the will. So then the trustee will be able to act and dissolve trust and then dispose of the properties and give everybody else that's a beneficiary their shares. So that way you can avoid probate, and it's always quicker, cheaper, and easier. The second benefit is for those tax consequences that we mentioned. Sometimes personal tax liability cannot really be fully avoided, but it can be set up in a way that there are no consequences, because the trustee continues to reinvest whenever a property is sold. For instance, all the funds and proceeds are considered part of the trust corpus. Like, you know, the trust owns that stuff until or unless the beneficiaries decide that the trustee is supposed to disburse funds to the beneficiaries, right? So if the trustee is instructed to keep putting the money back into the trust, then there's really no tax consequence until the very end when the trust is dissolved. If there are some funds that are dispersed out to the beneficiaries, then they definitely need to talk to the CPA to see what are the tax consequences in terms of their own personal income taxes. So generally speaking, you can avoid those taxes in your lifetime by just having the proceeds rolled over back into the trust. And then if it's an irrevocable trust, like I said, then it's not counted as part of your estate as the grantor. The third reason why people would like to create a trust is because of privacy and shielding themselves from bad plaintiffs, people that like to sue other people that they think have money. So how does that work? Well, with the trust agreements, the agreements themselves would state specifically, and the law allows you to keep the identities of the parties private. Only the trustee's identity is typically published because the title to the property that you're transferring goes to be held by that trustee. So people would see the name of the trustee. It could be a lawyer, it could be a cousin, they don't really know who owns the property behind that trustee and behind that trust, because the parties are prohibited from sharing that information unless it's by court order. If the court then orders you to share that, then you can do it. So how does that benefit you? Well, that means that somebody that's looking to make a quick buck or looking to just get rich really quickly off of you by suing you frivolously, it discourages them. It's a deterrent to plaintiffs that are just suing left and right, trying to see who they can get a settlement from, because they have to go through a lengthy court process before even being able to figure out who truly owns that property that they're trying to go after. And though that is a deterrent to plaintiffs that are trying to sue you, it also is good for privacy in the sense that people don't know your net worth, or that people don't know who owns a physical property, so they cannot be soliciting you with a lot of marketing materials and a lot of offers. So they will send things to the trustee, of course, and the trustee is just going to ignore those things. You can tell somebody's net worth sometimes by looking into the public records and seeing how many properties they are holding. So with the trust agreements, you name the trust, but if it's for purposes of anonymity or privacy, you typically want to name it a cryptic name or use the address of the property that is going to be held in trust. So for instance, you could name the trust, I'm sure you've seen this, they name it 555 Main Street Trust. So you'll see that, and some people would name it, the Smith Family Trust, because they're not really trying to be anonymous. They're just creating a small trust for the benefit of their children, and that is okay as well. Okay, and then the other way that the anonymity works is that when you create a trust and you have the beneficiaries, you could also have an LLC as a beneficiary. You could have a corporation, as a beneficiary, or you could later on in the future transfer a beneficial interest in that trust to an LLC. And then once you have an LLC, it creates another layer of protection, because people cannot easily see who's behind the LLC sometimes, because you could have an LLC where one of the members is actually a trust as well. So they don't really know who are the true owners of that LLC to begin with. And then, then they have to go into the trust to figure out who are the beneficiaries of the trust. And then the other part of the protection is the fact that LLCs shield the members, owners, from personal liability. It's a double layer of protection. Homesteads are always protected in Texas, just generally speaking, from the actions of creditors, okay? And they're protected from judgments and liens. But this is an additional layer of protection because of the obscurity that's involved as well. The other thing to think about is if you're an investor and you're pulling your funds together with other investors and buying, properties like apartment complexes or large plots of land and things like that, you could put them in that trust, right? And then you have several investors that are beneficiaries of that trust. If one investor gets into trouble and is being sued, that investor does not have to rely on insurance to take care of any lawsuit, right? You need this proactive type of protection so that the creditors or the plaintiffs cannot come and try to reach that property that's held in trust. And the reason why they cannot reach it is because you're just a partial owner. As an investor, you have other investors that are owners of the trust property as well, so they can't really put a lien against that property for that reason, because it's not 100% yours. So that's a good level of protection. We all know that people have insurance, you have liability insurance, but you know that the insurance companies are in the business of denying claims. They collect premiums and deny claims. That's basically their business platform. And that's why there's some of the richest corporations out there. So protect yourself proactively. You know, if you're an investor, you need that land trust for the most part, with a good level of anonymity. And you would also need to use LLCs as an added protection. If you are just an individual putting the trust agreement together for the family, you could keep it private or not, it's up to you. But the trust agreement is never ever filed. It's always held private, and only the parties that are involved know who they are. And you're not supposed to disclose that information to other people unless it's by court order, like I said before. So it is a great tool, and it's also a great tool to avoid probate. It's a great tool to continue to assign the beneficial interest without having to record anything in the public records. Because when you assign your beneficial interest, that person essentially just becomes a beneficiary of the trust, and then you don't have to publish it to the world who the new beneficiaries are. And also the same thing with contingent beneficiaries. Nobody knows. And then lastly, of course, it helps you save a lot of money from probate proceedings. It helps you save a lot of money from any creditors that are trying to attach things to the property. And it also helps you to establish your will while you're alive and have control of it. Remember that the beneficiaries are always in control of the title and the actions of the trustee, so they'll be able to tell the trustee what they want. And the way that the document is written, the beneficiaries are also protected in the sense that before any beneficiary can go out and sell his or her beneficial interest, he has to first offer that interest to the other beneficiary. So that everything is kept within the family. If you want it to be that way, if you're investors, you want everything kept within the group, the initial group of investors, so you protect your interest in that way by having the first right of refusal before somebody goes about selling their interest, you know, as part of that trust. We covered a lot of things, but of course there's a lot more involved, and no two trusts are like I said. So you do have to consult with a certified public accountant that is very familiar with the tax consequences and ramifications, and you also have to talk to a lawyer that's comfortable with asset protection in general, that has a holistic view of everything and is more of a proactive lawyer in terms of protecting you and your family. So those are the key components that I can think about. The trust agreement itself is a complex tool, but it makes sense once you've had a chance to talk to a lawyer and formulate what works best for you. So this is just my overview of it, like I said. And if you want us to cover any specific topics in future, make sure to put a comment below. If you found this video helpful, please hit the subscribe button so that you can continue to get future videos. And of course, make sure to share with friends if you think that this would be a useful video for them as well. Take care and talk to you next time.